Good morning and welcome to our public inquiry or public hearing into an inquiry into the state strategy for implementing unproclaimed legislation passed by Parliament during the last 20 years. This is the second time we're looking into that, and today we have special focus on the Electronic Transactions Act, Chapter 2205. I wish to welcome the viewing and listening audience to this 14th meeting of the Joint Select Committee on Finance and Legal Affairs. So today, the committee, as I say, is convening our first public hearing pursuant to the inquiry into the state strategy. What is our strategy for implementing unproclaimed legislation? And one may think it rather odd that we've gone through the process of taking a bill through all its stages in Parliament, and then the bill is there lying and waiting to be implemented. And some of these bills, they have far-reaching implications on the entire society. So today we're looking at the Electronic Transactions Act. And we know that we are in a system where electronic transactions take place every day. And yet, there are areas of the bill that we need to deal with and to make sure it has been monitored and that it's really implemented. We ask members of the listening and viewing audience to post or send your comments via the Parliament's various social media platforms, Facebook page, ParlView, Parliament's YouTube channel, and Twitter. So first of all, I'd like to welcome officials of the Ministry of Digital Transformation, which is a new ministry we haven't had before. And this is the driving ministry behind this legislation. I am Hazel Thompson-Aye, Senator Hazel Thompson-Aye, a member and chairman of this committee. I will now invite members of the committee to introduce themselves.
Good morning, everyone. I am Janzi Lachmiel. I am a member of the committee. Chair, I think that might be it for now. The member Scotland is on. I know he's juggling some other matters.
Okay. Any other members? All right. We have Mr. Saddam Hussain, Member Saddam Hussain. Member Lanti Lashmiel has already introduced herself. And Mr. Terence Dayal Singh, he's had to leave. All right. So Member Scotland. Some of the members are, unfortunately, they are juggling court matters, but we are proceeding nevertheless with this very important inquiry. We have officials of the Ministry of Digital Transformation in attendance, and I'd like to ask them to introduce themselves, please. Forgive my voice, I'm struggling with a little problem here.
Good morning, Chair. My name is Corey Belfon, Deputy Permanent Secretary of the Ministry of Digital Transformation.
Good morning, Madam Chair and Senator Lachmiel. I am Rudyard Davidson, Executive Legal Advisor for ICT.
Good morning, Madam Chair and members of the committee. My name is Denise White. I am a Deputy National Chief Digital Officer at the Ministry of Digital Transformation.
Good morning, Madam Chair and committee members. My name is Jatero Danatari Singh, and I am a Digital Transformation Associate.
Chairman, you're muted.
Advise you and the members of the public on the inquiry objectives. One, we're going to be looking at the factors that are contributing to the delay in the full proclamation of the Electronic Transactions Act, Chapter 2205. We're looking second objective, the sections of the act that can be implemented without delay. I would say without further delay because it's been delayed for some time. 3, the sections of the act that require more time and/or input for operationalization. And 4, the impact that the delay in the full proclamation of the Act has had on business and government transactions, privacy and data protection. I will now invite members to make opening statement. Mr. Corey Belford, Deputy Permanent Secretary in the Ministry of Digital Transformation. Maximum of 2 minutes, please.
Good morning, Madam Chair. Good morning, members of the JSC. Good morning, members of the public. The Ministry of Digital Transformation is pleased to be here today to present further insight as to support the objectives of this inquiry. And of course, given that the ETA is central to the work laid out by the Ministry of Digital Transformation and its mandate, which is to provide a new way of addressing the end-to-end delivery and consumption of goods and services to customers using appropriate digital technology. We intend to show via our answers and our insight that we remain committed to the progression of the specific legislative agenda that will enable the electronic environment required to do so. Thank you.
I'm glad to hear you say that we remain committed to this because it's so very important. And Trinidad and Tobago was in fact the venue of the regional workshop on e-commerce legislation harmonization in the Caribbean, held from the 29th of September to the 2nd of October 2015 in Port of Spain. It was actually sponsored by the government of the Republic of Trinidad and Tobago and other agencies. And we have a number of regional governments that have in fact implemented their legislation and are going forward. We will commence the questioning, and I'm asking, please, reminding members and officials to direct their questions and concerns through the chair, and activate the microphone on your devices when you acknowledge, and turn it off when you've concluded your contribution. The hearing will now proceed.
Madam Chair, do I have your leave to commence questioning?
You most certainly do, Mr. Scott, Member Scotland.
Thank you very much, Madam Chair. This is directed to the ministry. I don't know if director or the legal, but we want to look at the factors that are contributing to the delay in the full proclamation of the Electronic Transactions Act, Chapter 2205. In your submissions, you stated that there have been considerable technological advances over the time span that the legislation has been enacted to now, which require an updated approach to the legal and regulatory framework to support its full and practical operationalization. What steps, having realized that, what steps have been taken thus far to update the approach to the legal and regulatory framework beyond the consultation that was mentioned in your submission?
Thank you, Madam Chair, if I may. So what we have seen is several advancements as we submitted in our written responses. And we know that we've had a national ICT plan, which was the National ICT Blueprint of 2018 to 2022. The Ministry of Digital Transformation is at this point actually doing an update to develop a national digital transformation strategy. And with digital transformation, we are deliberately moving away from the notion that it's just technology. We have to look at the components of people. We have to look at the components of process. And the legal has to be an important pillar that supports the overall digital transformation agenda. So as we are working through the development of that strategy, which will prioritize strategic objectives on a national level as to where we're going with digital transformation, we are looking at the legal and regulatory framework to support those strategic objectives, especially with the advent of technology over the time period. So we're looking at new technologies that have been brought to the table and making sure that the legal and regulatory framework is in place to support that.
Well, thank you, Madam Chair, through you. What are some of the technological advances that have emerged and now must be considered in the redrafting of the Act? I want to drill down, Madam Chair, through you to specifics. So what are some of the advances that have emerged that must now be considered?
Madam Chair, if I may.
Yes.
Some of the technological advances that would have emerged over the past few years would have been artificial intelligence. You also have the emergence of blockchain transactions. And in addition, within the realm of fintech as well, cryptocurrency, as well as data mining. So we've seen some advances in that respect that could have significant impact with regards to the ETA.
Again, through you, Madam Chair, in your submissions, you stated at page 3, although Part 4, electronic signatures of the Act, has been proclaimed, the electronic signature regulation to be made under Part 4 have not yet been laid. What are the reasons for the delay in the presentation of these regulations to Parliament?
Through you, Madam Chair. The intention has always been, member, that the Part 4 regulations, and that is to say the electronic signature regulations, would be laid as companion subsidiary legislation with the Part 5 regulations, and that is to say the Electronic Authentication Service Provider, or EASP regulations. Specifically, the electronic signature regulations would provide for different types of electronic signatures and the applicable standards that would apply, taking into account that different transactions would require differing degrees of risk, and therefore different standards and therefore different types of signatures would apply. In like manner, where one considers an advanced electronic signature or a qualified electronic signature, as we would get into later in our submissions, the relevant regulations that would give effect to a qualified electronic signature would be the Part 5 or EASP regulations. So we thought it prudent that the Part 4 electronic signature regulations be laid as a companion package with the EASP regulations. Thank you.
Madam Chair, I'm going again. I'm focusing on the legal framework, and particularly the issue of the partial enforcement of the Act. And again, part of your submission has said that other parts of the Act can be proclaimed in short term, meaning in a very short while. Can you specify which sections of the Act you're referring to when you say other parts of the Act can be proclaimed in short term? What parts of the Act are you referring to?
And again, through you, Madam Chair, if I may. We consider that Part 6 of the Act, which deals with intermediaries and telecommunication service providers, as well as Part 8 of the Act, which deals with consumer protection or online consumer protection, as well as Part 10, which deals with miscellaneous provisions, including the regulation making power of the minister. Those parts of the Act can be proclaimed in short order. And as we've indicated, there will be some other parts for which work is ongoing, and upon completion of that body of work, those parts can then be proclaimed or operationalized. Thank you, Madam Chair.
Madam Chair, through you, can I ask them to give the committee a time frame because short term is not a time frame. Can I ask a follow-up and you can give us a time frame, please?
Certainly, and through you, Madam Chair, we contemplate that in the short term, those sections can be proclaimed within 6 to 8 months, and in the long term, because I think it's important contextually to clarify what is intended to be done in the short term and what is intended to be done in the longer term, because it certainly begs the question. So overall, and the full operationalization of the Act, we are contemplating and considering and putting things in place to effect full implementation during fiscal 2024. But in the short term, we believe that those sections or parts of the Act, which we have identified for immediate implementation operationalization, can certainly be accommodated within 6 to 8 months. We recognize that there is a procedure for that to be done, which involves working very closely with the Office of the Attorney General. So with the assistance and the interaction with that office, we are pretty confident that we can accommodate it within that time frame. Thank you, Madam Chair.
Madam Chair, through you again, what are the requirements, the technical requirements, the administrative requirements, infrastructural requirements that are needed for the proclamation of the said sections of the Act?
And again, through you, Madam Chair, if I may be permitted to deal with one of those, and I will simply put it under the rubric of administrative. And by way of particular example, I'm referring to the intermediaries and telecommunication service providers. Madam Chair, you and the committee would be well aware that the telecommunications sector has a regulator pursuant to statute, and that is the Telecommunications Authority of Trinidad and Tobago. So to the extent that we put in place that particular part of the Act that deals with intermediaries and telecommunication service providers, we would want to ensure that the relevant agency, that is to say the Telecommunications Authority, is ready to go with its procedures, because that part of the Act, among other things, deals with notice and takedown procedures. And so we would want to ensure that those procedures are ready to go. In addition to which, that part of the Act also deals with orders to be made by the minister in that regard. And again, those orders will be made pursuant to recommendations of the authority. So we simply wish to ensure that administratively, those things are in place so that there can be an orderly implementation of that particular section of the Act. In similar fashion, if I may be permitted very quickly, Madam Chair, the consumer protection part, which we have also identified as one for which there can be implementation in the short order. We are mindful that there is a consumer protection bill, so we simply want to ensure and complete the process of ensuring that any potential gaps or lacunas are addressed, that there is consistency and or alignment between what we're seeking to do online and what that broader consumer protection bill does. Thank you, Madam Chair.
Madam Chair, may I give way, and you will allow me a second round after another member has a question?
Before the other member comes in, I want to ask Mr. Belfon. I mentioned before about the big meeting that was held in Trinidad some years ago, and I just wanted to find out from you if there has been a study of the various jurisdictions who are our neighbors, who have in fact enacted electronic transactions law, consumer protection, data protection, privacy, and so on. So have you looked at the laws in Antigua and Barbuda, the Bahamas, Barbados, Costa Rica, Jamaica, St. Lucia, and to see if there is anything, I don't believe in reinventing the wheel, that we could learn from them to short circuit the process of having things brought into the legislation so that we can actually get on with it, because this impacts people in their everyday lives. It's not something that is remote. That is the way of the future that has come to us now. So is it that you have looked at the other jurisdiction and see how they've done things? It may very well assist you in doing what we have to do.
Madam Chairman, if I may ask someone else to field the question.
Yes, through you, Madam Chair. The Ministry with the responsibility for information and communication technology has over time engaged surveillance on what has been happening regionally in terms of not just electronic transactions, but data protection and privacy, since those are companion pieces of legislation and form part of that legislative framework that support the digital transformation agenda. So we have looked at it both from using our internal resources, also using consultancies that have been engaged by the ministries to determine what is what we call the right size for our environment. Because in as much as we get consultancies and technical assistance, especially from developed countries, we want to make sure that what pertains allows us to integrate seamlessly with what happens in the rest of the world, but is appropriate for our environment. When we bring legislation to the table, it must be legislation that is suitable for the environment in which we operate, and it allows for development of the particular sectors in mind without being particularly onerous and burdensome in setting up institutions to deal with operationalizing and implementation of the legislation.
And if I may, very briefly, Madam Chair.
I just wanted to respond, if I may, is that I remember a Chief Justice of Jamaica telling me many years ago when I was arguing with a committee for the best law. And he said to me, Hazel, you know, the best is the enemy of the good. So just bear that in mind, and so that we can proceed forward. I understand what you're saying, but sometimes we have to make do with what we can so that we can proceed for the betterment of our society and for the, it involves everybody, you know, not just the affluent. Every day we're using technology in the banks and all over. Even when we had COVID, you know, you have to get this passport and all of that. And, you know, we have to know how to use these things.
Chairman, may I have your leave to proceed? I have to leave at 11.
Yes, I did say proceed, member.
Oh, sorry, I didn't hear you. Yes, good morning, all. Jumping off from where we were at, I want to ask a couple of questions about the consultancies. Now, I hear what you're saying with respect to finding the best fits and all of that. But I want to break this down as simply as possible. Is it that the act we have now, is it not enough to cater for all the technological challenges, but can it work for something? Because the way I look at it, something is better than nothing. And while we are looking for the best fits when it comes to electronic transactions, when it comes to data protection and so on, and we want to reach the highest standard and be on par with everything, you're waiting on something to fit you well, but you're walking naked in the meantime. We have nothing. So I want to really know if what we have right now on the statute books with respect to electronic transactions, with respect to data protection, because as you said, they are companions and they go hand in hand. Is it impossible for us to, is there some detriment that we will suffer if we were to implement it as it is? And then work on amendments, because, you know, ordinary laws, you have to cater to a changing environment. And when you're dealing with laws that deal with technology, I don't know that we can ever say that we will be up to date. We will amend the law today, and tomorrow we will see something come up that will change things, and you may need a change to your regulatory environment. The legislation, and that's why you have the ability to amend laws, right? It's to be able to adapt to the changing environment. But if we were to wait until we get it perfect, will that ever really happen? Is that, to me, that sounds, as when you're talking about technology, that sounds like a very unrealistic ideal. And I think most members of the public who are, just vaguely familiar with technology would feel the same way. So tell me if you don't think that what we have right now isn't better than nothing at all.
If I may, through you, Madam Chair, to the member, we certainly agree with that premise. And in fact, just to quickly contextualize it and further to the question that the chairman would have asked, we would have specifically looked at the electronic transactions legislation in Dominica and Antigua and Barbuda. And there is a consultant's report that would have indicated to us, and we would have similarly found that our Electronic Transactions Act in the Commonwealth Caribbean is certainly far ahead of the others. So that in direct response to your question, we have the basis of something or legislation or a framework that can empower and facilitate our digital transformation agenda. But further to that, again, if I may, Chair, it is not as if we have not been making the strides in the rollout of the services. We have, in fact, been using the sections of the Act which have been proclaimed, which have been operationalized, and we have taken advantage of that to roll out a suite of services. And we recognize that upon full proclamation, an even broader suite, because we envisage that for the full digital transformation agenda, the entirety of the Act would have to be proclaimed. But we certainly agree with your premise to return to that point, that working with the parts of what we have, albeit really good legislation, is recommended as opposed to being stuck and not moving forward until we have it perfect. So we have actually been proceeding along that way. Thank you, Madam Chair.
Through you, Madam Chair, just for the benefit of members of the public, you said that you would have been using what has been proclaimed to roll out some services. What are some of the services and really to the public? How has the public benefited from what you've rolled out so far? Give me some examples.
Certainly, and again through you, Madam Chair. We would have indicated earlier in this call that Part 4 electronic signatures would have been proclaimed. And even prior to that, in 2012, Parts 1 through 4 would have been proclaimed. And then, of course, Part 7. And so what that has meant is that we would have been able to use the single sign-on TT Connect form of ID to enable and facilitate the single electronic window TT BizLink, which I'm sure all of the members are familiar, which would have facilitated business in Trinidad and Tobago. It was a business facilitation tool, and that the empowering of TT BizLink was a direct result of using the parts of the Act that have in fact been proclaimed.
Okay.
There are other. Yes, please. Thank you, Madam.
Okay. I'm happy you mentioned TT BizLink. I'm a user of TT BizLink, so I'm a bit familiar with it. Have you all, based on what you've been able to do in terms of offering government services through BizLink to the public, how would you say that there's been a comparable response to utilize the proclaimed parts of the legislation by the private sector? Specifically, I'm thinking about the banks, but any private sector entity. Has your ministry been monitoring the use of the tools that you say that you all have been using on the BizLink side, for example, by the private sector, in order again to enhance customer experiences, particularly as the chairman said, coming through COVID and all of that? Has it been used at all?
Through you, Madam Chair, if we look at the financial services sector, which because of the nature of it is one of the most risk averse, they have rolled out a plethora of online products, most popularly internet banking, which is used by a large number of the population. And there have been no representations in our outreach to the private sector and the financial services sector that says that because these parts of the Act have been unproclaimed, they have been unable to roll out. In fact, quite the opposite. They have been able to roll out a suite of the online services under what pertains in the Act today.
So if I may briefly, go ahead. No, I was just going to add, can I proceed, or did you want to follow up?
Please, go ahead.
Yes, and if I can briefly add in terms of your original question relating to corporate Trinidad and Tobago and the suite of e-services which would have been availed to them. In addition to TT BizLink, of which corporate Trinidad and Tobago obviously would be a large user, there's also e-tax filing, for which the corporates of Trinidad and Tobago or the private sector would also be huge users and consumers of the service. Thank you, Madam Chair.
So do you feel satisfied then that there's a high rate of usage by private sector so far with what has been proclaimed?
If I may speak for my colleagues and through you, Madam Chair, it is difficult to be satisfied when you realize that there is so much more of the digital transformation agenda. What I think is a more appropriate feeling at this point is we feel that an appropriate amount of take-up and usage has been done.
Okay.
But we remain committed to an even fuller availing of those services and usage by the citizens and public of Trinidad and Tobago.
And you mentioned that in your outreach to the private sector. So is it that getting more take-up from them and perhaps nudging them in the direction of using what is available and getting their buy-in in terms of what you intend to bring on stream? Is that a big part of your ministry's mandate? And is that something that you are actively pursuing now and intend to pursue in the future?
And again, through you, Madam Chair, and in answer to the member's question, most definitely, and in fact, I thank you for that question, because the whole digital transformation agenda is built in 3 pillars, as we would have indicated, of which digital economy is a huge part. So there's digital government, digital society, and the digital economy. And the only way to advance that pillar of digital economy is working hand in hand with the private sector as ICT services not only are made more available and there's greater uptake, but its contribution to GDP is increased. And the only way in which that can be done, and therefore that can be realized, is through the partnering with the private sector.
Okay.
Thank you.
Chair, not a follow-up, but another question which I had been assigned. I don't know if you wish for me to come back to my next round, but I do have to leave in a few minutes.
Yes, go ahead. Having regard to your schedule.
Yes, thank you, Chair. Thank you very much.
I'm captive here.
Okay, thanks again for all your answers so far. I want to touch a little bit on the consultants that you mentioned in your submission. You indicated that you all have engaged with some consultancies. So if you can tell us a little bit about the expertise that you have recruited through these consultancies, a little bit about the cost, and whether it's actually still ongoing, or if not, if they have been completed, what has been the product that you've derived from these consultancies?
Thank you for the question, Honourable Member, and through you, Madam Chair. The consultancies have been taking place over a period of time that would have actually predated the Ministry of Digital Transformation. So the exact details as regards costs would have to be the subject of a subsequent submission to the committee, having to source that information from those relevant agencies. Some of the expertise that has been engaged, however, there have been experts from UNCITRAL itself, which is the United Nations Commission on International Trade, which has come up with the model law. There have been experts in ICT law regionally as well. But further details of those consultancies can be sourced from the relevant agencies and presented as a subsequent submission to the committee. In terms of are there consultancies that are ongoing? No, none of those contracts are currently active.
Okay, so you could certainly in writing let us know how many consultancies were undertaken, cost, and the product, whatever would have been derived out of them. So we look forward to receiving that in writing then. My last question, I want to find out a little bit more about the support that you get from the Office of the Attorney General. Have you all been liaising with the Office of the Attorney General and to get their view? Let me just give you a little background on why I'm interested in this question particularly. I've worked on legislation in the financial services sector where we've utilized consultants to basically redraft and repackage an entire legislative suite. And when we get to the Office of the Attorney General, because we worked with a foreign consultant, it was like somebody taking a reading pen and going through your very detailed 500-page report and bill, and they often have a very different perspective on what can work and what cannot work with respect to drafting and so on. So have you all engaged with them together with the consultants and so on who are coming from UNICTRAL and all of that to get their input on the proposals for amendments and so on? Is it, or are you all waiting until perhaps you have a sort of semi-final product to present to them and get their feedback?
And through you, Madam Chair, again, I am grateful for the question because I am happy to report to this committee that yes, there have in fact been consultations. There has been ongoing consultation with the Office of the Attorney General, and in particular, as we have developed policy in respect of some of these very unproclaimed sections. We've developed the policy, and as the member would have indicated, based on her experience, we would have also developed what we call drafting memorandum. And we would have shared both the policy and the drafting memorandum with our colleagues at the Office of the Attorney General, and there has in fact been this level of interaction and guidance. And so it is taking that into account why we feel with some degree of confidence that we can bring these unproclaimed pieces of the legislation into operationalization within that relatively short time frame. Thank you, Madam Chair. Thank you, ma'am.
No, I'm glad you said that, because in your submission, you stated Part 6, intermediaries and telecommunications service providers, Part 8, consumer protection, Part 10, miscellaneous, can be proclaimed immediately. That's your submission to us. What has been the reason for the delay in proclaiming these sections of the Act if they are ready to be implemented? What is the proposed role of the ministry in the implementation of these sections?
Again, if I may, through you, Madam Chair, when we say that they can be implemented immediately, what we mean is that they can be implemented immediately now that a certain amount of work has gone into that process. The work of consultation, the work of the policy refresh, the work of reviewing, the work of ensuring, as my colleagues would have indicated earlier, that they are consistent with international or regional best practice, but more particularly, that they are consistent with Trinidad and Tobago's digital transformation agenda, because we, like you, Madam Chair, do not subscribe to the proposition of wholesale adoption. We look at it, we look at what is best practice, we look at what works, but it must be tailored to and customized to what would give effect to what Trinidad and Tobago is seeking to do. So having done that work, we can now say that things can be done immediately. So that is the context in which the statement was made.
So you use that word immediately. So perhaps next week I'll be seeing something or hearing something that these things are coming on board. Immediately has one meaning for me. I don't know if immediately has another meaning for you. I await your response.
Well, indeed, so please, Madam Chair. Madam Chair, to the extent that even in the context of immediately, there are agencies such as the agency, if I may be so bold, and I say this respectfully, on which you sit, and then that other place in which other members may sit, which would have a role in the immediate implementation of regulations that come to it and or amendments to the act that come to it. But in terms of our readiness to release those for that further action, we are at a place where we think that that can occur in relatively short order. And that is the context in which the statement was made.
So you would wish to amend immediately to short order? Because
I'm sorry, please, could you...
You would wish to amend your statement using the word immediately to in short order.
I would accept the invitation to so do from you, Chair. Yes.
All right. Because language has meaning, you see? So that don't raise my expectations and then drop them.
We are so guided, Madam Chair.
I am obliged.
Chairman?
Member Hussain, you had something to say? I would wish to invite you to do so. Please proceed.
I don't know my colleague if she wants to just intervene because I know she may have to step out for a minute. I will give way, please, Chair.
Well, I wanted to indicate that I was stepping away for a bit, but just one thing, Chair, that I wanted to pick up on before we lose traction, coming off of your question. And again, I want to be very clear and I want to break this down very simply for members of the public. Am I to understand what the response coming from the ministry is that there are bills or regulations that are ready to be laid and brought to the Parliament? Because that is the impression that I got from what was said. So I think it's, we would like to have that clarified. Are you actually ready for regulations to be laid or amendments to be brought? I think that's important to our report and our inquiry.
And thank you. And if I may, through you, Madam Chair, just to clarify, and I'm glad that the member asked the question, because we would have indicated in terms of the parts that were ready for proclamation, we would have indicated that those parts involve consumer protection, intermediaries, and telecommunication service providers. And part 10, I believe our submissions would have so reflected. In those three that we have identified, regulations do not need to be brought. So we would have identified part 5, the electronic authentication service providers, as certainly one for which regulations would need to be brought, and we would have indicated that there is a proclaimed part 4, for which there are also regulations that will need to be brought. But for the 3 that we said can be done in short order, having been so advised by the chair and having so accepted, the ones that can be brought in short order are those 3 for which regulations would not be necessary, at least in the first instance, in order to proclaim them.
I'm asking about the part that need regulations. Are those regulations ready?
They have been drafted, but the reason why we say that they're not, we never attach the word short order or immediate to those is because both the policy and of course the review of the drafting memorandum with which the member is familiar, that review is still ongoing and would benefit from the ongoing consultations with the Office of the Attorney General.
Good, thank you very much. I'll take my leave now, Madam Chair, and I'll return it shortly.
Madam Chair, we're not
How
hearing.
much additional time, sorry, you think is recommended for this review process? Things that you need to be done. Any idea? I don't want to suggest the phrase to you, or the word to use, but could you give us a timeline?
Indeed, so please, Madam Chair, and feel free to suggest the wording because we would have accepted it in the first instance. But the timeline is consistent with our position that it can be done in fiscal 2024. And we believe that a holistic review and development and settling of those regulations, and of course the policy informing them, can be accommodated within that time frame.
Mr. Hussain? Member Hussain?
Thank you very much, Madam Chair. I just have a question for the officials with respect to a companion piece of legislation, because we understand the implications of the Electronic Transactions Act having to deal with a lot of personal data. And there's a companion piece of legislation that we refer to known as the Data Protection Act. And within that act are certain safeguards that are given to persons and statutory protections. Now, we are looking at the implementation of the Electronic Transactions Act. Is it that this act can be fully operationalized without the full proclamation of the Data Protection Act?
And if I may, again, through you, Madam Chair, and we welcome that question because I think it is important to both this committee's deliberation as well as to the public of Trinidad and Tobago. We consider that a full operationalization of the Electronic Transactions Act must be accompanied by the full implementation of the Data Protection Act. But we recognize that even with the parts of the Data Protection Act that are in fact proclaimed, and in particular I would refer to the general privacy principles that are in fact have been proclaimed, and therefore that both public and private sector bodies must conform to. And those principles would require that any persons, any data controller, sharing or otherwise processing the data of any data subject must observe certain principles. So the Act, as it has been proclaimed, provides a basic set of safeguards. And we recognize that once the Office of the Information Commissioner is fully operationalized, that part has been proclaimed, as the member is aware. But once that office holder, or once that body corporate, the Office of the Information Commissioner, is fully operationalized, the degree of protection or the framework of protection that would facilitate free and robust electronic communications would certainly be in place. Thank you, Madam Chair.
Madam Chair, may I?
Yes, please.
Thank you very much, sir. Now, the point I'm getting at is that you did mention that there's a proclamation of the general privacy principles, but I'm looking at enforcement. The Electronic Transaction Act will deal with sensitive personal information, in particular persons' financial information, which is very sensitive. And without the Data Protection Commissioner, then there's really no enforcement inbuilt in the Act. So my problem is that my issue that I'm taking is whether or not you're not comfortable with having this legislation brought forward in a fully operational manner in the absence of the Data Protection Commissioner. Because what is the redress that a person will have? Let's just say there's a breach of confidentiality with respect to any of their financial information pursuant to the Electronic Transaction Act.
And again, through you, Madam Chair, and we certainly appreciate the member's question and the fact that it gets straight to the core of the issue that we've been raising, and it is why we described these two pieces of legislation as companion pieces of legislation. The Senate would have had deliberations within the past couple of weeks or so on the whole framework of the Data Protection Act and the time frame within which it is to be fully operationalized, including the Office of the Information Commissioner. And it is precisely for the reason that the enforcement mechanisms, as well as the safeguards that attend the transmission of one's personal data, that those mechanisms and those safeguards must be in place so that there can be full use of electronic transactions and or that regime. In other words, that we can fully operationalize the Electronic Transactions Act. So we recognize that. So that it is not by accident at all. In fact, it is entirely deliberate that we say that the time frame within which we want to bring these two pieces of legislation to full operationalization are entirely consistent. We want to do it as a matter of urgency, and we have indicated within fiscal 2024. I would say one thing further with the leave of the chair, though, that for full enforcement of the Data Protection Act, as the member has indicated, it is certainly desirable and necessary to have the Information Commissioner and or the Office of the Information Commissioner operationalized. But there is also the remedy in judicial review, as the member no doubt would be mindful of, that for certain sections of the Act, the Data Protection Act, that have been proclaimed, to the extent that anybody, a public sector or private sector body, is acting in a manner contrary to that, and therefore the whole notion of a breach of statutory duty, because having regard to the fact that Part 1 and the general privacy principles have been proclaimed, nothing would prevent an aggrieved person from making such an approach to the court until such time as we have those formal enforcement frameworks in place. Thank you, Madam Chair.
Madam Chair, just in response to that submission, without getting into any legal arguments, I don't believe that I'm looking at judicial review as an appropriate remedy in this instance. I'm talking about someone financial information being breached, the confidentiality of that being breached. Judicial review is just a court reviewing a body in which it doesn't substitute a decision of that body. It just reviews to see whether or not the decision was illegal or not, proportional or not. So in my respectful view, I'm not looking at it from that angle. I'm looking at preventing something like this from happening. If I just looked at the Electronic Transaction Act and the Data Protection Act, and both were passed almost around the same time in 2011, I believe. And that coincides in showing that these two pieces of legislation work hand in hand. Now, my whole concern again is whether or not, let me put it in this way, what is holding back? Because if the Electronic Transaction Act may be codependent on the Data Protection Act, then in order for the Electronic Transaction Act to be fully operationalized, we must have the safeguards put in place. What then is really holding back? One, the appointment of the Information Commissioner, and two, going towards the full proclamation of the Data Protection Act.
And Madam Chair, if I can briefly respond to this in two parts. The first is, I need to correct something that was suggested, and that is, with the greatest of respect, that the operationalization of the Electronic Transactions Act is not dependent on the Data Protection Act. What it is, and what we would have indicated, is that for the full liberalization of both trade and commerce in an electronic environment, we would need to have the protections that are afforded by the Data Protection Act. But technically, the full implementation of one does not require the implementation of the other. So that is the first point. And the second point is that we would be happy, as far as the Ministry of Digital Transformation, to have discussions on the timetable for full operationalization of that act. But we're also mindful of the particular remit of this committee. So if the chair would therefore give us leave to address issues of the Data Protection Act, we would be happy to so respond. Madam Chair.
We look forward to hearing from you, sir.
Thank you, Madam Chair. So as we would have indicated, as would have been clearly articulated when this matter was ventilated in the August chamber of the Senate, the Data Protection Act and all of its various parts, including the full operationalization of that enforcement mechanism, that is to say, the staffing and the structure of the office, that is being attended to with a great degree of urgency, mindful of the necessity for the protections under that act that the full implementation of that office would provide. So what we would have also indicated is that when that office is fully operationalized, the act contemplates that there are certain procedures that must be put in place. And just by way of example, and in answer to the member's question, there must be procedures for sharing of data. There must also be procedures for what we call privacy impact assessments. And so what we thought would be appropriate is that while that office is, because the section of the Act has been proclaimed, so it's just a question of a position being filled. But we thought it prudent and efficient that the relevant procedures and in particular the policies underlying those procedures, that those could be worked on, the privacy impact assessment models and the data sharing models, etc., that those templates could be worked on and be in a place so that when that office is fully operationalized, there would be a basis upon which they can begin and therefore upon which persons whose data would be processed, those persons can rely. And we have taken the opportunity in that regard to consult with international partners who have guided us based on such legislation and procedures which are in place in other jurisdictions in the crafting of those types of instruments. Thank you, Madam Chair.
Madam Chair, my final...
I just want to ask him, when you talk about the international persons, are you talking about regional or is it international as opposed to the regional people who were on this journey with you in 2015?
And just to be clear,
are you liaising with the international in the normal sense meaning of the word, or are you also including the regional partners who are moving forward or have moved forward?
I was specifically referring to our international partners and multilateral agencies included among them. And we have also been taking note of what has occurred in our region in respect to legislation that may impinge upon the Data Protection Act. And yes, and there are legislations, there are jurisdictions of note where courts have found certain challenges with regard to the state of readiness and or development of their data protection legislation. And I will pause there in response to that question.
Madam Chair, my final question is, can the Ministry just indicate to us very briefly what steps have been taken to fill the vacancy of the Office of the Information Commissioner?
Can you repeat the question, please, Ma'am? Through you, Madam Chair. What steps?
Yes, sure. What steps have been taken to fill the vacancy of the Office of Information Commissioner?
I will answer this question in two parts, and I will reserve the second part for my colleague. Steps have been taken, steps had already been taken, because the member may be aware that I think it would be 4 years ago or so, 3 to 4 years ago, advertisements would have been placed both regionally, well, both locally and internationally and regionally for the position of Information Commissioner. So having regard to the fact that that section of the Act, of the Data Protection Act, would have been proclaimed, so that the positions have been advertised. There has also been ongoing work, to the member's question, in building out the Office of the Information Commissioner, because it would somewhat be defeatist or not give full effect to the work that that office has to do, to the extent that an office holder is recruited, appointed by Her Excellency the President, and on day one, there is no structure or infrastructure in place upon which that office holder can perform the work that is required to be performed. I will pause and hand over to my colleague for any further comments.
Madam Chair, it is noteworthy that the Office of the Information Commissioner actually does come under the remit of the Office of the Prime Minister Communications. So they are actually the ones who are responsible for doing the recruitment of that position. We have been working with them, as my colleague would have indicated, in terms of getting the supporting pieces of that office ready, so that when an office holder does occupy that post, that person is able to be up and running from day one. So we have been working most notably with the European Union and through their connections, getting data protection and privacy experts to help us get the processes in place, give us the templates, the playbooks, so that we're not starting from scratch here. And we are making provision so that when that office holder sits on that chair from day one, they are able to be fully functional.
Thank you. Now, in your submission, you stated that the telecommunication service providers will only have a duty to monitor customers' personal data if they acquire specific knowledge or if something is brought to their specific attention, which requires them to actively monitor. Given that such monitoring will be conducted in accordance with the provision of the Interception of Communications Act, would the full proclamation of the Electronic Transaction Act have any further implications for telecommunications sector?
If I may, through you, Madam Chair, I think it may be necessary to properly contextualize certainly our statement, because it has led to some somewhat unintended consequences. What we would have intended to communicate, and therefore what we are communicating now is that the telecommunication service providers would have an obligation to monitor content, and they would have an obligation to take down content once they acquire knowledge that content as posted is in fact either criminal or otherwise unlawful or undesirable. And so in terms of any ongoing monitoring as may be contemplated under the Interception of Communications Act, I don't believe that was in the context or that fits within the context of what we were seeking to communicate. In any event, if I may also respectfully suggest, the relevant standards of proof are somewhat different, because we are not talking about having a reasonable belief or suspicion. We are talking about actually of unlawful or criminal content actually being brought to your attention, so that, for instance, when the regulator gives notice to a telecom service provider that there is material that is either criminal in nature or otherwise unlawful, it is brought to their attention and the notice is given. They in turn would engage the notice and take down procedures. And so the point that we were trying to make is to simply clarify that there is no ongoing duty to be monitoring traffic across their systems. There is no per se liability for content posted on their systems. It is only when they have actual knowledge that, and some may argue constructive knowledge, that those liability procedures and therefore the takedown procedures will be engaged. Thank you, Madam Chair.
I think both of us, in fact, are comforted by your clarification. So thank you.
Thank you kindly, Madam Chair.
Yes, we didn't want to go away with that misconception. So that I'm glad the opportunity arose for you to clarify that you didn't mean what you said. Now, regarding the current use of fintech service providers such as WePay in the public sector, in the absence of a fully established regulatory framework for electronic transactions, what protective measures are available to guarantee consumer security when conducting electronic financial transactions? Because they're happening every day. We're using it in a number of ways. And, so we need to, have you assure us that there are things in place.
Yeah, thank you, Madam Chair. Electronic payment providers, of course, would come under the regulatory framework of the Central Bank of Trinidad and Tobago. So we are assured that for any sort of electronic transactions that do involve payments, and specifically in the fintech area, we know that the Central Bank plays a regulatory role as regards this particular sector.
Thank you. Members, any further questions for the officials?
Not at this time, please, Madam Chair. MP Hussein.
You anticipate another time?
Well, I hope the next time we appear to determine the operationalization of the law.
Well, we are a little closer, I think, in determining what is happening. The Ministry of Digital Transformation, you know, there's still a lot of work to be done. I see that you are going forward in a number of areas, but this is so critical. This is no longer the future. This is the present. And, you know, since 1980, if you remember, King Swallow sang the song, you know, Trinidad, the godfather of the Caribbean. It's not only about money, it's about leadership in the Caribbean. And we want to be sure that Trinidad and Tobago, you know, continues to lead in critical areas of governance in so many things. And, you know, we don't feel too comforted that we are leading in the ways that we would want to go forward to assist our citizens to enter this new century. So there's a lot of work to be done. We are happy that a lot has been happening so that we could have everything fully implemented, fully proclaimed, so that we can move forward. And we know that you are continuing to work assiduously because it's no longer the future we're dealing with present. And people are using electronic transactions on a daily basis. The elderly have been brought kicking and screaming into the 21st century. And we so frequently depend on having the young people. Last week I was there and in India, and the Air India is telling me that there's only one flight a week in a particular airline. And I am saying, you know, this is not correct. And they say, not seen any. So I had one daughter in Florida and the other one in Trinidad, and they were both conferring, and they were able to say from the computer, and they will say, no, this is the way forward. This is what, and they, while in Air India, they're fighting up. My daughters were able to get me flight so I could be here today. Otherwise, I'd be waiting until Saturday to come into Trinidad. And I know I had this meeting today. So I was able to come in Monday night. So because, you know, people were able to use all the data, all the transaction, all the electronic things that some people are not okura. You know, people from my generation aren't always okura. So we have to really depend sometimes on the younger people to do things for us. And that's one of the things I would like to see you all doing, more education about electronic transfers, about buying online, because people are so dependent on other people assisting them who may not be as honest as they should be. And, you know, even when we do things in Trinidad and Tobago, I had a meeting on recently, and whereas we were using both VPay and we were using other transaction PayPal, we found that people were complaining that things were not happening with VPay as they should, you know, and PayPal, things were moving a bit smooth. So there's a lot of, we're still on a learning curve. And we want to move forward, and we need to have all hands on deck. We see the need for very clearly for collaboration between and among ministries and within ministries. So there's a lot that needs to be done, but I'm also satisfied that there is a lot that is happening. And the ministry is new, and you have a dynamic minister, and you have a competent staff. You appear very knowledgeable. And I must thank you for what you've done today to educate the populace on what is happening and how you're going to move forward. And I would urge you to confer closely with your Caribbean partners who have moved forward in a number of ways and are moving forward, so that we can all move together to realize that really we are in a brave new world where things are not like our grandparents or even some of us when we were young, and we can't be left behind. So I would like to congratulate you on what you have done so far. I would like to thank you for coming here today and sharing with us what is happening. So we feel a little heartened, but not completely satisfied. But I know the work is going on and is going to continue. So thank you very much. And I would now ask for closing statement from your chief official, who we've heard a lot from him this morning. And let's hear your closing remarks, sir. Of course, you can delegate, but I anticipated it, yes.
Thank you, Madam Chairman, members of the public. Certainly, we would have been pleased to have been here to provide the relevant explanations and insight as required. And of course, on a lighter note, with regards to the experience, you can rest assured that the Ministry of Digital Transformation is making great strides, Moko Jambi strides, as we like to say, in terms of having that support readily available for you. So in the very near future, you can expect integrated service centers to assist you in terms of that digital experience that you embarked upon, so that you would have that assistance to be able to get the end result that you want. That is our focus in terms of making that access to technology easier via digital literacy and support, amongst a plethora of other projects that we have in the pipeline. And certainly from the legislative framework and agenda, as I would have indicated before, we will continue to work assiduously to advance that, specifically in the realm of electronic transfers, electronic records, contracts, and in the context of the DPA and the ETA. All right, so I'll hand it over to my colleagues if they have any further comment.
I don't know that it could have been articulated more succinctly or more completely than the Deputy Permanent Secretary has. Allow me to simply add my thanks to you, Madam Chair, and to your entire committee for permitting us the opportunity to respond to both the committee and to the public of Trinidad and Tobago in terms of what the Ministry of Digital Transformation has been doing in both the furtherance of its digital transformation agenda, as well as specifically how the Electronic Transactions Act and the Data Protection Act, how those pieces of legislation intersect that digital transformation agenda, all with the goal of providing direct benefits and palpable benefits to the people of Trinidad and Tobago. Thank you, Madam Chair.
Well, I was feeling very comforted until you used the analogy of the Moko Jambi, because when I see the Moko Jambi, I get a little nervous that they will fall, you know? And I've seen them fall as well, so that I don't know if you want to change from Moko Jambi and say just giant strides, yes?
We're guided, please.
Thank you for being here, and we hope that Moko Jambi will stay upright.
Thank you.
The meeting is now adjourned.